In the criminal justice system, parole means temporary or permanent release of prisoner before the end of a sentence as an incentive for good conduct in the prison. The term is derived from the French phrase "Je donne ma parole," that is, I give my word. The Supreme Court in Sunil Fulchand Shah versus Union of India 2000 held that parole does not amount to suspension of sentence. The Prison Act 1894 and the Prisoner Act 1900 do not contain any specific provision pertaining to parole and furlough. However, Section 59 of the Prison Act empowers states to make rules for shortening of sentences as a reward for good conduct. Also, prison is a state subject in 7th schedule. Now, eligibility for the grant of parole according to 2010 parole for all guidelines. To be eligible for parole, a convict must have served at least 1 year in jail, excluding any time spent in remission. The prisoner's behavior had to be uniformly good. The criminal should not have committed any crimes during the period of parole if it was granted previously. The convict should not have broken any of the terms and restrictions of his or her previous release. A minimum of 6 months should have passed since the previous parole was terminated. Note that prisoners convicted of multiple murders under the anti-terror UPA are not eligible for parole. Parole versus parole, furlough and parole are types of conditional release which aim to balance offenders' right with that of the society. Now, offenders must adhere to the terms of order authorizing parole or parole, such as periodic reporting to local police station. Now, in case of parole, parole can be awarded in case of short-term detention. Parole is allowed in case of long-term detention. Parole usually lasts for 1 month. Parole usually lasts for a maximum of 14 days. Parole is a specific justification for parole is necessary. For furlough, it is intended to break the monotony of imprisonment. Parole can be given multiple times. Parole has a limit. Parole can be denied even when the prisoner makes out a sufficient case if the competent authority is satisfied that releasing the convict would not be in the interest of the society. Furlough can also be denied in the interest of society because it is not granted for any specific reason. Parole is granted by the divisional commissioner. Furlough is granted by the Deputy Inspector General of Prison. Moving on to PIL, that is public interest litigation, the Supreme Court interpreted and defined PIL in Janta Dal versus HS Chaudhary 1993 case as a legal action started in a court of law for enforcement of public or general interest. It is not defined in any statute and has been interpreted by judges to consider the interest of the public at large. In India, it was introduced in the early 1980s, and Justice V.R. Krishna Iyer and Justice P.N. Bhagwati were the pioneers of the concept of PIL. It is a power given to the public by courts through judicial activism. However, the person filing the petition must prove to the satisfaction of the court that petition is being filed for public interest and not just as a frivolous litigation. Now, PIL can be filed either in High Court or in Supreme Court. The principle of locus standi does not apply in case of PIL, that is, any Indian citizen can file a PIL provided it is not filed with a private interest, but in larger public interest. At times, the court can take suo motu recognition. Now, the idea has been borrowed from American jurisprudence evolved in the 1960s, where it was designed to provide legal representation to previously underrepresented groups like poor, racial minorities, unorganized consumers, etc. It mainly focuses on areas like basic human right violations of the poor, conduct of the government policy in case of pollution, terrorism, road safety, constructional hazards, etc. Now, amicus curiae is an individual or organization who is not a party to a legal case but who is permitted to assist a court by offering information, expertise, or insights that has a bearing on the issues in the case. Simply, he or she is a friend of the court. The decision of whether to consider an amicus brief lies within the discretion of the court. Supreme Court and High Court maintains panel of lawyers who are assigned amicus work in criminal appeals. Moving on to Ombudsman is an official who is appointed by the government to investigate individuals' complaint against a company, financial institution, business organizations, especially a government department or public entities, or and attempts to resolve and the raised complaints by either process of mediation or giving recommendations. In India, there are different kinds of ombudsmen, like anti-corruption ombudsman, Lokpal for the union. The term Lokpal was coined by Dr. L. Singhvi in the year 1963, and Lokayukts for the states, banking ombudsmen, insurance ombudsman, income tax ombudsman, etc. Moving on to FIR, First Information Report is a piece of information reported in point of time given to a police officer in writing as per the provisions of Section 154 of CRPC. The information must relate to cognizable offense and the victim or someone on his or her behalf gives information and lodges a complaint with the police. The term First Information Report has not been defined in CRPC. Instead, the term is used in Section 207, which requires magistrate to furnish the accused a copy of FIR. Zero FIR, unlike FIR, which is restricted by jurisdiction, a zero FIR can be filed by any police station, regardless of whether the offence was committed under its jurisdiction or not. The concept of a zero FIR is relativity and was introduced on recommendation of Justice Verma Committee in the aftermath of Nirbhaya gang rape case in 2012 to put a legal obligation on police to take quick action and prevent them from using the excuse of absence of jurisdiction. Whereas FIRs have serial numbers assigned to them, zero FIRs is assigned the number 0, hence the name. After a police station registers a zero FIR, it is to transfer the complaint to a police station that has the jurisdiction to investigate the alleged offence. Once a zero FIR is transferred, the police station with appropriate jurisdiction assigns a serial number, thereby converting it into a regular FIR. Moving on to charge sheet, as per section 174 of CRPC 1973, charge sheet is a report which is made by the police officer after completion of final investigation. It is thus prepared after FIR and charges an individual that is accused for some or all the crimes specified in those reports. Moving on to bail. Bail is a conditional release of a person accused of a crime awaiting trial for an amount pledged for the appearance of the accused when the same is due in court. The person pays the money which acts as the surety. The CRPC does not define bail but only categorizes offences under the IPC as bailable and non-bailable. The CRPC empowers magistrate to grant bail for bailable offences such as a matter of right. This would involve release on furnishing a bail bond with or without security. In case of non-bailable offences which are cognizable, the accused can be arrested without a warrant. In such, a magistrate would determine if the accused is fit to be released on a bail. Types of bail in India. Regular bail. It is a bail which is often granted to an individual who has already been arrested and is kept in police custody. Interim bail is granted as a temporary means and granted for a short period of time, either during the time of pendency of an application or when the application of anticipatory or regular bail is pending before the court. Anticipatory bail is a type of bail which is given to someone who is anticipating of getting arrested for a non-bailable offence by the police. It is thus obtained before an arrest is made. Transit anticipatory bail is sought when a case against a person has been or is likely to be filed in a state different from the one in which the person is likely to be arrested. Statutory or default bail, as per law, once the maximum period of investigation, that is 90 or 180 days from the arrest, provided the state and case is over and no charge sheet is filed, the accused becomes entitled to be released on bail, which is called default bail. This default bail is known as statutory bail. Supreme Court in Bikramjit Singh versus State of Punjab 2020 and Fakhre Alam versus State of UP in 2021 declared statutory bail under the first proviso to Section 167 Clause 2 of CRPC a fundamental right. According to Supreme Court, statutory bail is a fundamental right and part of right to personal liberty under Article 21 of the Indian Constitution. Rationale is the right of the accused to seek liberty takes precedence over the right of the state to carry on investigation beyond a stipulated time limit, which varies for different laws. Moving on to types of offences, there are three categories of offences recognized by CRPC 1973, which are cognizable offences, non cognizable offences, bailable and non bailable offences, compoundable and non compoundable offences. Now, cognizable offences, these are those offences in which the investigation authority can arrest the accused without an arrest warrant. Defined under Section 2 of CRPC 1973, non cognizable offences are those in which the investigating authority cannot arrest an accused without an arrest warrant. Now, permission of the court is not required for cognizable offences. Investigation can be initiated as soon as FIR is filed. For non cognizable offences, the permission of court is required. Investigation can begin only after the court issues an order. Now, for severity of crime, cognizable offences are serious crimes. Non cognizable offences are less serious crimes. Examples of cognizable offense would be murder, theft, kidnapping, etc. Non cognizable would be assault, cheating, defamation, etc. Now, for bailable and non bailable offences are those offences which the accused person has a right to be released on bail. These are listed at bailable in the first schedule of CRPC or by any other law. Non bailable offences are those which the accused is not entitled to be released on the bail as a matter of right. Now, bail here is a privilege. However, under bailable offences, bail is a right, matter of right. Intensity of the crime is less serious in nature. However, for non-bailable offences, the intensity of crime is more serious in nature. Examples will be minor traffic violations for bailable offences, property offences, cheating, bribery for election, etc. For non-bailable offences, examples would be murder, rape, kidnapping, certain types of economic offences, voluntary causing grief, hurt, etc. Now, quantum of punishment in bailable offences is for less than 3 years, with some exceptions. For non-bailable offences, the quantum of punishment may extend to life imprisonment. Now, power to grant bail. Bail is granted as a matter of course by the police officer or by court. For non-bailable offences, the court or the police officer has the discretion to grant bail on case-to-case basis. Example in Rashik Lal versus Kishore Khangchand Vadani case, SC held that right to claim bail in a bailable offence is an absolute and indefensible right. In Masab Ali versus Irsan case, SC held that discretion to grant bail must be exercised with great care by balancing the right of the individual and the interest of society at large. Moving on to compoundable and non-compoundable offences. Compoundable offences are of a less serious nature which usually impact an individual. These can be remedied through an agreement or settlement between the parties. Non-compoundable offences are graver and more serious, having an impact on society as a whole rather than just the victim. Examples of compoundable offence would be hurt, theft, adultery, defamation, dishonesty, misappropriation of property, etc. Non-compoundable, these typically involve willful infliction of great bodily harm, injury by hazardous weapon, dishonest misappropriation, kidnapping, abduction with intent to kill, etc. Parties involved. Now, a private individual is only one who is impacted. For non-compoundable offences, it impacts both the individual and the society. Now, settlements can be made with or without the court's approval. It can only be quashed, and no settlements can be made, and it cannot be compounded. So, which is in the name non-compoundable offense. Filing of the case. The cases are often brought by the private individual. Cases are brought by the state in case of non-compoundable offences. So these are offences which are against the state, and compoundable offences are those which are brought by a private individual. Now, whether the charges can be dropped or not, charges against the accused may be dropped with the consent of the party that is wronged. Now, the accused cannot have the charges dropped against them dropped in case of non-compoundable offences. Now, trial after settlement. When a settlement is reached, an accused may be declared free, and there is no need for a new trial. Now, for non-compoundable offences, it needs to complete trial, which will find the accused innocent or guilty based on the evidence. Justification of the differentiation: as these are not very serious offences, the accused may get leniency. Now, for non-compoundable offences, the accused cannot get away with punishment because the deed was so horrible and unlawful. Moving on to plea bargaining, it is a pre trial negotiation between the accused and the prosecution when the accused agrees to plead guilty in exchange for certain concessions by prosecution. It is a bargain where defendant pleads guilty to a lesser charge and the prosecutor in return drops more serious charges. It is not available for all types of crime. Now, plea bargaining in India became a part of Indian criminal justice system by Criminal Law Amendment Act of 2005. It allows plea bargaining for cases where the maximum punishment of imprisonment is for 7 years. Now, where the offenses don't attract socioeconomic conditions of the don't affect the socioeconomic conditions of the country, and when the offenses are not committed against women, child below 14. Now, moving on to ILP, that is Inner Line Permit. It is an official document issued by concerned state governments permitting inward travel of an Indian citizen who are not permanent residents in a protected territory. Origin: under the British rule, ILP was implemented as a part of Bengal Eastern Frontier Regulation 1873 to protect the commercial interest of the British Empire by preventing its subjects, at the time Indians, from trading in these regions. ILP was continued post independence to address the local concerns about protecting the interest of indigenous peoples from outsiders belonging to other Indian states. Currently, in early 2023, ILP is applicable in whole or parts of Arunachal Pradesh, Nagaland, Mizoram, Manipur, Lakshadweep, Himachal Pradesh. Moreover, Sikkim has recently constituted a committee to analyze the potential application of ILP. Note for foreigners: the Foreigner Protected Area Act requires foreigners to obtain a Protect Area Permit, that is PAP, to visit certain areas in India. That'll be it for 150 keywords in the polity series.